Hello, and welcome to another episode of the award-winning Cause for Action podcast. I'm Scévole de Cazotte, Senior Vice President at the U.S. Chamber of Commerce Institute for Legal Reform. For the past few years, claimants' lawyers and litigation funders have set their sights on bringing the worst parts of the U.S. lawsuit system to countries around the world like Australia, Canada, the Netherlands, and the U.K. This troubling trend is especially problematic in the United Kingdom, which is seeing a rapid increase in collective action lawsuits against businesses. My guest today is Kenny Henderson, partner in the London offices of CMS, one of the premier defense law firms in the UK. Kenny has acted on many of the highest profile claims in the UK to date and is an expert in class and group actions. Thanks for joining us today, Kenny. The last time you joined us on this podcast, Kenny, we discussed the Merix v. MasterCard case and the possible implications of the ruling for class action claims waiting in the wings. In this post-Merix world, what has been the actual impact of the decision on opt-out class action litigation?
Hi, Scévole, and thank you very much for the invitation to speak on this important topic. So, what's been the impact of the Supreme Court decision in Merix? So, as you'll recall, we've discussed this before, the Supreme Court decision in Merix really interpreted and then applied what the certification test and the approach to certification will be under our competition class action mechanism, which the UK introduced by statute in 2015. And in short, the Supreme Court imposed a very low threshold, a very low barriers to entry for class certification. And that was a split decision, actually, by the Supreme Court, by the judges on the Supreme Court, with the minority expressing concern that the approach that was the majority view and the one that held, they said, and I'll quote directly from them, they said that that approach would very significantly diminish the role and utility of the certification safeguard, but that's the place we're in now. So what has been your question? What has been the impact of that decision? Well, there's been two most obvious and immediate impacts. First of all, we've seen an unblocking of the competition class actions that were filed after Merix and which were waiting for the Supreme Court to rule on the certification threshold. And so subsequent to the Supreme Court ruling, we've had 8 certification decisions by the tribunal, all of which have granted certification of those class actions. They have all been certified. Those include Merix itself and a number, and I'll not go through all 8 of them, but they've got some very significant claims here. So there is a claim against Apple concerning commissions charged in the App Store, and that the number of people in the class there is apparently 19.6 million. That's what is being advertised by the claimant law firm. There's a claim against Qualcomm, alleging abuse of dominance in the pricing of chipsets, that the class size there is 29 million. We also have a claim against BT, British Telecom, of a class size of 2.3 million. So these are very big claims, and these are all now being certified. We've seen 2 carriage disputes, two claims, 2 class actions being brought forward where there has been carriage disputes, and where they have been certified only on an opt-in basis, and that's where the claimant law firm and advertisers try and persuade people to join in. But all the others have been certified on the very powerful opt-out basis, more akin to the US style, where the class is automatically coalesced. Those two where there's been certification battles are the Forex cartel, in relation to Forex cartel, foreign exchange cartel, and also the trucks cartel. That certification has just been handed down today, hot off the press. So that's the first and most obvious impact of the Merix decision. The second impact is it encourages more claims, because the threshold is a low threshold and there is very little reference to substantive merits. It's only when the tribunal is looking at opt-in versus opt-out, and then only at a very high level do they even consider merits. That in of itself is encouraging and will continue to encourage more claims to be brought through this procedure. So I guess where we are is analogous to the US a few decades ago, before a more rigorous approach was taken to class certification. We're in a worrying stage right now.
Fascinating. Indeed, quite a bit of new cases to observe. But another case that we ought to discuss in the UK Supreme Court is the decision, the £3 billion pound data protection class action against Google. Can you tell us more about the case and what it means for data protection claims in the UK?
Yeah, of course. And so we at CMS, we were involved in this case. So I should declare that interest. We acted for two interveners at the appeal to the Supreme Court stage. This was an interesting case for a number of reasons. It was brought using a very historic procedural device in the UK, what we call our representative action mechanism, which has been around for hundreds of years and is very rarely used in the UK, and it's typically been rarely used because it's not historically thought to be effective for the use of for the purpose of bringing class actions. But the Court of Appeal approved its use in Lloyd and Google, and that caused a huge amount of interest and led to equivalent claims, further claims being brought akin to Lloyd and Google, inspired by their claim. The Lloyd and Google claim itself is a data protection claim, but not a data breach claim. It's what's described as a data misuse claim. And the allegation there is that Google, for a period of 6 months, without the knowledge and without the consent of phone users, was harvesting their information about their browsing. And the first interesting feature, as I said, about this claim is the fact that it was brought using the representative action mechanism. So it was brought on behalf of, I think, 4.1 million people, none of whom signed up. So it's similar to a US-style class action device. The second feature, interesting and unusual feature about it, was how they were framing the losses. And the representative alleged that the people affected should recover damages for the loss of control of their data, which was a new and innovative approach. Now, the claim failed at the Supreme Court stage for two main reasons. First of all, the court said that as a matter of substantive data protection law, so this is not talking about the mechanism, but as a matter of substantive data protection law, it was not possible to claim for loss of control of damages. You can claim for pecuniary losses if your credit card details are taken and whatnot, and you can claim for distress, which is the typical damages that are sought on a data breach claim. But you can't claim damages for loss of control of data. So that was the first main finding. And incidentally, that was under pre-GDPR. The question is still open on GDPR in the UK on loss of control of damages for loss of control. The second, the second reason, the second primary reason it failed for, was that the claimant class had not articulated a basis for proving harm on a class-wide basis, even if damages had been available on loss of control. So that's very good. It's good news for data protection class actions attempting to use that device.
Good news indeed, but what do you think that may happen next in this area? Because it seems like the door is still open for more cases in this area.
Well, you're absolutely right, because it was a reasonably lengthy judgment, and it was capable of being disposed solely on the substantive law point about data protection cases. But actually, the judgment went on to say quite a lot about the representative action mechanism and actually illustrate and set out other circumstances in which it could be used. And so that is unquestionably increasing the risk of this device. So it said, first of all, that the device is capable of being used in a bifurcated approach, such that on an opt-out class-wide basis, it could be used to establish liability. On a bifurcated basis, the people who are class members then coming together in a group on an opt-in basis to seek their damages. And the judgment's very clear that would be possible. The judgment also acknowledges, which shows a degree of understanding of how litigation funders work. It also noted that may not be attractive to litigation funders, because they still have to win at the first stage, and a funder would have to fund that first stage on liability, but there wouldn't be any recovery there. So there's a question mark on whether that bifurcated approach would be used. The second feature, though, and I think one of more concern, and where we may see some ingenuity from claimant law firms, and I'm going to quote from the judgment here, which is, I think, the most important sentence in the judgment, is that it said that there is no reason why damages or other monetary remedies cannot be claimed in a representative action if the elements can be calculated on a basis that is common to all members of the class. So they are saying, for the right types of cases, you can use this very powerful opt-out mechanism to claim damages. You don't need to go down the bifurcated approach. So I think what we're going to see is the claimant bar thinking creatively, perhaps looking to what's happened in the US and the sorts of claims that are filed in the US for inspiration to identify the sorts of claims that can fall within that, that doorway that the Supreme Court has identified for this device. So that is definitely an area of increased risk as a result of Lloyd and Google.
Interesting indeed. You mentioned third-party litigation funding. That's a topic that we've addressed in this podcast on several occasions, and it was announced just last week that the UK Supreme Court will rule on the legality of TPLF in class action against truck manufacturers for price collusion. That's very interesting, and would you be able to say a few words on this? I mean, I know it just came out last week, but I think it's a fairly interesting issue.
Yeah, happy to. And, it's going up to the Supreme Court. So it's been, it's already been examined by the initial tribunal and the Court of Appeal. It's a high profile matter. It's a very technical argument. So I'll just take you through some of the background and the listeners through some of the background. So first and foremost, English law has seen a real development, increased flexibility, increasingly flexible approach taken to third-party litigation funding and funding arrangements that are permissible between claimant law firms and their clients. So around about 30 years ago, England introduced what are called conditional fee agreements, and under them, the law firm can reference their recovery. They can hinge their recovery by reference to their hourly rates. So, for example, if a predefined and agreed criteria of success are met, they could perhaps get an uplift on their hourly rates, perhaps a 50% on a good outcome. That CFA, conditional fee arrangement regime, does not permit law firms to take a recovery, a portion of the share, a portion of the recovery in any action, whether from damages or settlement. But around 10 years ago, we introduced what are called damages-based agreements, which I think are the closest analog to contingency fees in the US. And under damages-based agreements, the claimant law firm can be paid a portion of the of a sum recovered, again, whether by settlement or trial. But the regime there is quite restrictive. It's quite restrained, and that's in two main ways. So first of all, hybrid arrangements are not permitted. And what I mean by that is that the present understanding is that the law firm entering into a DBA they can get a recovery, they can get a portion of the recovery, but that's all they can get. So what you couldn't have is a fully flexible agreement, which would say, look, if we don't prevail, we get, say, 50% of our hourly rates, and if we do prevail, we get 30% of the recovery. It's kind of all or nothing in relation to the recovery. So they got to take a lot of risk. And that restrictive regime that we have around the damages-based agreements, many people think that has reduced the appetite for claimant law firms to enter into those DBAs. Now, that area is being looked at, and there are draft alternative rules being circulated. So that could be relaxed in the coming few years. I'm going to come back to the trucks case in just a moment. I'm just laying out the context here. The second very restrictive element, or quite restrictive element of damages-based agreements is that they are not permitted under the competition class action regime for opt-out claims. They're not allowed. The claimant law firm is not allowed to enter into an arrangement that is formally a damages-based agreement. Now, funders will often have an equivalent agreement, but would maintain and would say it's not a damages-based agreement. So they would often have an arrangement whereby they will take a percentage recovery, whether by settlement or a trial, or perhaps a multiple of what they have invested in the case. And because if they're not subjected to, if that's not a damages-based agreement, and they're not subjected to the DBA guidelines, the DBA rules we have, then they have that flexibility. They're allowed to have hybrid agreements. That is fine. They're not restricted in that way. And this is where we reach the point in the trucks case. Now, one of the truck defendants is saying and is arguing that the funder of that case, the arrangement they have, is formally a damages-based agreement and therefore should be subject to those restrictions that I've identified. And that is an opt-out competition class action. So if it's a damages-based agreement under the regulations, it's impermissible. And so what it comes down to, and this is the technical bit, is the snappily sounding section 58 AA of the Courts and Legal Services Act 1990, which says that an agreement between a person providing advocacy services, litigation, or claims management services, where the amount to be paid is by reference to the recovery, is formally a damages-based agreement. Now, as I mentioned, that definition entails advocacy and litigation services. So that's obviously the law firms. And so what the defendant here, the truck manufacturer, is saying is that the litigation funder is providing claims management services, and therefore this is a DBA, and therefore it's impermissible in this claim. And that's the argument that's being run. Now, it hasn't succeeded at first instance or at the Court of Appeal, but the Supreme Court is sufficiently interested in it that they've granted permission to hear that appeal. So, as I say, it's quite technical. Watch this space because it could have broad-ranging impacts.
Fascinating. I think we'll look at this case with interest. I'm mindful of the time, and I think that in conclusion, maybe you could tell us a little bit of your impressions and predictions on how this UK patchwork of class action procedures will evolve in the near future.
Sure. Yeah, I think patchwork is a good word because we don't have an equivalent to Rule 23 in the US, which just encompasses all causes of action. We have a variety of opt-in mechanisms, like our group litigation order mechanism, which results in claimant law firms advertising for claimants. We have a iterative approach to opt-out claims, very powerful US style, with initially only for the competition field, and then we've got this very powerful potential representative action mechanism as well. So what we've seen. What we will see in the next few years is continuing innovation by claimant law firms, looking to push the boundaries, looking to expand the scope of representative action mechanism. But there will no doubt be a lot going on at the policy level as well. And the UK government has been looking at expanding and introducing new opt-out mechanisms for different types of claims. And there's more and more activity. Just a couple of months ago, we saw the launch of the Collective Redress Lawyers Association, called CORLA. Which is an organisation of the leading UK and US US firms, claimant firms that are active in the UK, coming together to share information on best practice, shared interests, and a stated lobbying objective. So we're going to see a lot more activity both on the claims and on the policy level. There's not an end point; it's an ongoing debate.
Great. Well, thank you very much, Kenny. We'll hopefully have another podcast on future cases. Thank you so much.
Great. Thanks very much.